All right. Good evening, everyone. My name is Michael Kernodle. I'm here with Graystone Investment Group. I am the brokerage manager of Graystone Real Estate. We're happy to have you here for our training tonight, which is entitled The Intersection of Probate and Real Estate. We have our awesome presenter tonight. Her name is Lynn Walder, attorney Lynn Walder. She's right here in the Tampa Bay area. She has a wealth of knowledge on this subject. And I know this is a hot topic that most people want to know more about. So we're going to dig into it. In the link, in the chat feature, there's a link where you can tap on that PDF. It's going to tell you all the points that we're going to take care of today. And there's a few other links for you as well. But without any further delay, we're going to hand it over to attorney Lynn Walder. So let's go ahead and get started. Thank you, Lynn.
Thank you. Hello, everybody. My name, as you know, is Lynn Walder. I'm an attorney in the Tampa Bay area. My practice at the moment is in St. Petersburg, Florida. I was in downtown Tampa for about 20 years. I've been practicing for almost 30 years. And the benefit of that is I hope that I've made most of my mistakes already, and you're going to get to benefit from that. So we're talking about real estate and probate and why that intersection matters. Probate. I know you know it. I don't know if you know what that word actually means. The literal translation, it's a Latin word, and it means to seek the truth. Very cool, because it's exactly what happens in the probate court. Probate court is the place where people have to go when someone has died and assets were only in that person's name, meaning the asset was not held jointly and the asset did not have any beneficiaries. We're going to keep this topic to real estate. There are many states in our country, about a dozen, maybe 2 dozen, that you can actually have beneficiaries on real estate. Hang on to that. We'll come back to it in a little bit. Okay, this is why you need to know about probate. If you're selling a piece of property or you're investing in a piece of property and the person, the owner, has died and there were no joint owners for that piece of property and there was no beneficiary for that piece of property, you're going to have a small visit with the probate court. You, of course, personally will not have to go to probate court. You're going to have to, though, deal with the lawyer that is handling that probate. Here's why. That piece of property will not be able to be sold until the probate court issues paperwork giving the okay for that title to transfer hands. All right, so far so good. It is important at this point now to talk about the difference between homestead property and non-homestead property. If all you're ever involved in is commercial real estate, you will not come across homestead property because homestead property cannot be commercial real estate. Homestead property is exclusively a residential piece of property that the person has their main residence in that piece of property. That's where they get their mail. That is where they're registered to vote. And in Florida, and let me say, I am talking exclusively about Florida law throughout this entire time. I'm only licensed in Florida, and Florida law is what I know. Now, I'm sure there is a lot of overlap, so this information will still be pretty good. So homestead property, the homestead, again, one homestead in Florida. You can own 10 pieces of property or more. Only one piece can be homestead. If it is homestead property, you will be dealing with the probate attorney who is bringing that piece of property through the probate court and coming out on the other end so that you can then either invest in that property, or if you're the buyer of that property, or if you're the realtor and you're selling that property. But nothing can happen before it goes through probate. So who exactly is your client? if you're involved in selling a piece of property in probate? That is a great question. And it's a little bit complicated because it changes. The moment the person dies, that property is an asset of the estate. If I died, it's the estate of Lynn Walder. That piece of property, if it is homestead, before it gets into your hands, will pass to the heirs of the person who died, the decedent. And then, as a realtor or as a buyer or as the investor, you will then be purchasing the property from the heirs. So, yes, you heard correctly. The property first is an asset of the estate, and then, not so magically, but when the court signs the paperwork that the probate attorney has filed with the court, it will then become the asset of the heirs, and the heirs, whether it's one or many, will then be the sellers of that property. That's for homestead property. If we're dealing with a piece of property that is non-homestead, that won't apply. And your seller will either be the estate or it may be the heirs. It depends on if the property is going to be sold while the estate is opened, or if the property is going to be sold when the estate is closed. That's going to be up to the probate attorney. There's a lot of different reasons why we might want to sell the property while it's in the estate. Or we might want to pass that property to the heirs and the heirs will sell it. So that's a little bit different than if it's a homestead piece of property. I just want to make sure there's no questions. Mike, I'm not doing a great job looking at the...
Okay. Yeah, you're doing awesome. So if you have any questions, maybe you just joined us. There's a feature there with the hand up. Just hit that and go unmute and we'll answer any questions. Or you can go into the chat and type your questions there and we'll answer. But right now, no questions, Lynn. We can proceed.
Let's keep going.
All right.
So I just want to be really clear about this. And interestingly enough, yesterday I had a client. She was married. Her husband died. Before they got married, which was 20 years ago, he bought the property when he was single. They got married. They never put the piece of property into her name with his. It was never held by the husband and wife. It was only held by the husband. And he died. She came into my office and insisted that why not just put the property in her name? And the will says so. So why can't we just do it? That is a classic probate issue. You can't just do it because you have to have the probate court say that it's okay to do. We all know that the property is going to go to her, and I tried to walk her through the scenario because she just did not want to believe that we had to go through the probate process. So think of it this way. In your line, if you're a realtor, if you're an investor, if you're selling property or buying property, the way to do it is by transferring a deed. If the person who owned the property is dead and they are the ones who are selling, meaning they are the grantor, but if they're dead, they cannot sign the deed, right? Because they're dead. That means there is no way to transfer that property if it was only in their name. No title company will do that. No realtor can do that. If you're going to try to record a deed that a dead person hasn't signed, it won't work. So in order to be able to get that transaction to work, you have to go through the probate process. There are a lot of different kinds of probate. That particular process for this particular client that I was speaking with is what we call a summary probate. Not important for your needs. That would be, the probate attorney who's handling that. But all probate does not take a year or more. Certainly there are certain situations where it does, but the summary probates, a very, very quick probate in the probate world would be maybe 3 months. And that's quick, you know, for the lawyers. I know it doesn't sound quick, but that's quick. Okay.
Okay. Well, Lim, we do
Yes.
have one question just popped in. Thank you, Tom, for asking the question. It says, if the property is in a revocable trust, would that avoid probate?
Great question.
Mhm.
If the property is in a revocable trust, and if the property was homestead property, and again, it will depend, but if it was homestead property, there may be a need to go through a short probate. I'm gonna do my best at keeping this as a very short explanation, but I want you to understand the homestead part of this. In Florida, there are a lot of different kinds of homestead. We use that word to describe a lot of things. Most of us know homestead as a piece of property that gets a tax exemption because it's your homestead. And that is true. And we call that a homestead exemption. There's a whole nother kind of probate that comes up in, there's a whole nother kind of homestead that comes up in probate law. That homestead we refer to it as constitutional homestead because it speaks of this in the Florida Constitution. The Florida Constitution says if you have a homestead property, it is protected from creditors, meaning that nobody can force you to sell your home to pay off debt. That doesn't mean that they can't put a lien on your property, but it does explain why big public figures like O.J. Simpson and F. Lee Bailey and 10 dozen others come to Florida. They take all of their money and they buy multi-million-dollar mansions, usually in West Palm Beach. They do that so that when they get sued, because they're doing it in anticipation of being sued, they can protect their money by sinking it into their real estate. So, for instance, when O.J. Simpson got sued and he was found, this was in civil court, and he was found liable for something to the tune of $30 million. And I'm sorry if I'm not getting those facts exactly straight, but he was sued and he owed the people who sued him somewhere between $15 and $30 million. The only thing they could do is file a lien against his house. They could not force him to sell his house. That is what we call protected homestead in Florida, because your property is protected during your lifetime from having to sell it to owe debt. Okay. When you die, if your house is passing to your heirs, it is still protected. It's a really nice benefit of owning a homestead property in Florida. How do we know it's protected, and how do you get it to be protected after you die so that your heirs don't have to pay any debt by selling your house? That is part of the probate process. So all the way back to that question, if a property is an irrevocable trust, do you have to go through probate? If you want to protect that homestead from any creditors, it will be necessary to file a petition with the probate court seeking that homestead protection. That's answer A. Answer B is even if it is homestead and you don't care about protecting it, there are no creditors, we don't have to go through that process of protecting it, then you would not have to go through the probate process. And you can just sell that piece of property out of the trust. The trustees would be the ones to sell that property out of the trust. And you do avoid probate. All right.
Thank you, Lynn, for that.
Good.
That was very insightful. Do we have any other questions before we move forward? If you just joined us, thank you so much for joining us. You can always put your question in the chat, or you can hit that raise hand feature and we'll answer. Do we have any other questions before moving on? All right, Lynn, let's go ahead.
Let's keep going. So we have a piece of property. We know now if it's homestead or if it's not homestead, what to anticipate time-wise for selling that. If it is a piece of property and it's in probate, meaning the person who owned the property died, no beneficiaries, no joint owners, it will be in probate. And the frustrating part for you as an investor, a realtor, a buyer, a purchaser, probate is a process, and it can be a long process. And the rhyme and reason about how long it takes is really dependent on so many things. A lot of it, and we saw this, we meaning probate lawyers saw this during COVID, the courts became so backed up because nobody was in the courthouse. Everybody was working from home, and it was an incredibly inefficient way to move probate cases along. Things that would take me a week took 2 months. And it was problematic when I had real estate that we had closing dates and I couldn't meet any of my closing dates. I will tell you, as a probate attorney, when I'm selling real estate through the probate, I will always put in my contract that the closing date will be the date we're trying to close, or whenever we get all the necessary documents from the court. And I put that in my contract because otherwise, and I already know, chances are I'm never going to make the closing date. And I tell people that right up front, because probate is, you just can't really know when we're going to be able to get all the documentation to be able to get that title to pass cleanly. I think those everything we just talked about is probably the most important thing for you to know on the real estate side as a realtor, an investor, a buyer. But I will tell you some of the ways that you can avoid probate is in Florida to have beneficiaries on the real estate, and that will totally avoid probate. Because don't forget, the assets that have to go through probate are those assets that were only in the name of the person who died, the decedent, no joint owners, no beneficiaries. Those are the assets that go through probate. And so, yes, if you have beneficiaries on all your assets, meaning money and real estate, those will avoid probate.
Hey, Lynn, we do have a question from Viral. Thank you, Viral, for asking this question. He says, what about liability protection from the lender on homesteaded property?
Interesting. The lender's liability, I'm not positive what kind of liability we're talking about, other than if we're talking about we can be sure that it will close. Absolutely, the property eventually will close. It's a question of getting the order from the probate court allowing that property to change hands.
Ma'am,
Go ahead.
I can explain my question, ma'am. What
Great.
you were suggesting was that the O.J. Simpsons of the world get protection from creditors. That protection is not applicable to a lender who has given a loan to a person to purchase a property, correct? Or a HELOC.
Gotcha. So we're talking, and by the way, I'm glad to see you, by the way. Hi. A lender, as far as a HELOC or a mortgage, they're always protected because the property is the collateral for that loan. And so the lender, They're first in line for protection, and that property cannot sell until they're satisfied. Now, I suppose in 30 years, I've never come across it. I suppose I'm coming up with a situation where how could a lender be cut out of the deal, so to speak? If an heir inherited the property and then they quit claimed the property to someone else, absolutely, the lender could be left out. But the law will still protect that lender because a quitclaim title, a quitclaim deed does not have the kind of protections, the warranties, guarantees that the other kind of deeds have. So that lender is protected. They might have to, and quite frankly, I've never seen that. I was just thinking, how could they possibly be left out? And they could be temporarily left out if someone just simply tried to quitclaim property. But don't forget, a quitclaim deed, the whole theory behind a quitclaim deed says that I am selling to you whatever interest I might have in this property. So if I inherit property, the property's worth $200,000 and $100,000 is a mortgage or a HELOC, that quitclaim deed is only giving my interest, that $100,000. That quitclaim deed does not actually leave out any lender. So the lender absolutely still, because that property is collateral, they always are protected. I hope that answers that question.
Yes, ma'am. Thank you.
Okay, we have one more question from Annie Garcia. Thank you, Annie. She says, how do we best advise our clients concerning avoiding probate?
That's a great question. And I got to tell you, the answer is a little disturbing because the bottom line answer is you need to send them to a probate attorney. And it sounds so self-serving. Actually, not a probate attorney, I'm sorry, an estate planning attorney. In Florida is very, very serious about the rule or law that says nobody can practice law without a license. And so any non-lawyer giving any kind of legal advice, that's a problem. As a matter of fact, if you go down to a courthouse and you ask a clerk, presumably the clerk is a non-lawyer, if you ask the clerk, can you please help me fill out this form? They won't do it. They'll say no, and they'll tell you to find a lawyer. So the real and the good answer is estate planning attorneys, their job is to advise clients on how to avoid probate. And quite frankly, an estate planning attorney, a very, very good estate planning attorney, should also do probate work, because the estate planning happens before the people die. Probate happens after people die. Being a probate lawyer makes you a much better estate planning attorney, and vice versa. And a lot of my practice, at least 50%, is estate planning. And that's the kind of thing I do almost every day. I talk to people about how to avoid probate.
Yeah, thank you so much for that. That was awesome. Do we have any other questions before we move on? It's a lot of great information, Lynn. We have one more from Viral. You want to unmute Viral and ask that question?
Yes, thank you, Michael. Lynn, we have one more question, which is what we come across as investors very frequently. We're looking to buy properties from people who have recently passed away, and the probate may not have gone through. Is there any kind of public information or court process which can allow us to understand who the heirs of the property are, so that we know whom to contact in order to purchase the property from them?
Oh, yeah, that's a great question. You should be able to, at the very least, find out who the probate attorney is. And I'm unsure if you can do that through the public records, but you, at the very least, and I'll find out if, I mean, the websites I get into with passwords. I get into the clerk of court websites for whatever county it is in Florida. I don't know if you can see that information without a password. At the very least, you can always call the probate court of the county where the property is held, and they can tell you the attorney's information that's handling the probate case. And I just want to take that one step further, and we kind of touched on it earlier. As an investor or as a buyer of real estate that is in probate, the name of the seller will be, for your purposes, for the purposes of the contract, not for the deed, but at least for the contract and all the addendums, will be the personal representative of the estate. In other states, you might all be more familiar with the word executor. In Florida, we call it personal representative. Exact same thing, just a different phrase. So executor or personal representative of the estate will be the name for the seller on your contract for the sale of real property. When it finally gets to the stage of getting to the title company, if it's homestead, it will pass into the names of the heirs. If it's not homestead, it'll, as long as we're selling the property through that probate estate, it will continue to be the name of the personal representative.
Awesome. Awesome. Okay, we have another question from Osvaldo. He says, will a trust fund avoid probate completely? Thank you, Osvaldo.
Okay, here's the lawyer's favorite answer. It depends. So if assets are in a trust, let's say generally you will avoid probate. Every now and then, it may not avoid probate. The example that we talked about earlier was if there is a homestead piece of property in a trust, and it's important to maintain that homestead protection, it will be necessary to go through probate to get a petition in order protecting that property for homestead protection. Otherwise, usually assets that are in a trust will avoid probate. But I also want you to know that having assets in a trust may not be the best way to avoid probate, because there's a lot of other different ways. It gets complicated.
All right, I think we had another question from Annie Garcia. Annie, did you have one more?
No, you answered it, Lynn. Thank you very much. I appreciate it.
Sure.
Okay, lots of great questions tonight. I hope everyone's taking notes. If you're just joining us, you're here with our probate training here at Graystone Investment Group. If you have a question, just type it in the chat. If not, Lynn, we're going to go ahead and keep moving forward with the rest of the information.
All right, let's see where we are. The last, so we talked about the creditors. You know, if there are multiple beneficiaries, so the mom and dad had 4 children, mom and dad are both dead, and now the 4 children are inheriting the house, that will tend to be something that will slow up the process of you purchasing the house out of the probate estate, because to get 4 people to agree tends to be difficult. So that's just another thing that happens. The way I try to avoid that is I try every day to counsel my clients that when we're doing probate, we're doing a business transaction. And I try, a lot of times not very successfully, to speak to people in a way that I can convince them to separate their emotions and all that emotional attachment from selling the house. And you can imagine it doesn't always go so well. If everybody can get on the same page, and if everyone is willing to sell, the home that they grew up in, which, it's a tough thing. But that's always something else that, even if we're done with probate and now the house is in the kids' names, the 4 kids, it can be tough. But there's nothing else to do about it other than hopefully to convince them that it's time to sell and move on. And I think the only other thing I want to offer, which probably doesn't have a whole lot to do with what you all are doing as far as the real estate side of things or investing or buying, but estate planning, you can see, is important. It does not have to break the bank. It is so important to be able to put a plan together, and you don't have to wait until you're 60 or 70, because most people, not all the time, most people do not know when they're going to die. And so an estate plan, to have one, either as soon as you have assets in your name, and you could be in your 20s, and you could have inherited $100,000. And usually a 20-something-year-old that inherited $100,000, either it's not going to be there in 5 years, so who cares, sort of, or it's going to be in a bank and no one else's name is on it. And so that's why some estate planning, that example shows that estate planning is important. Estate planning is not meant to be carved in stone. You don't do it when you're 20 or 30, and then by the time you die in your 90s, it's still good. It's not. Estate planning is for today and tomorrow, maybe 3, 4, 5 years. If you do it when your kids are young, things are going to change, and they're going to grow up, and someday they're going to help you manage your finances. So your estate plan starts when you're young, and it follows you as you age. And when you have a good estate plan, amending it, modifying it as life happens is not as difficult and daunting as wishing and hoping, and someday we're going to do it, someday we're going to do it. And hopefully you do it before something happens, and then you're going to wish you did it, because the cost of estate planning is a fraction of the cost of probate and the headaches and everything else that come with it.
Wow, great explanation to be prepared for the future. So we have another question from Annie Garcia. If you want to unmute Annie and ask that question, that would be awesome.
Thank you, Lynn. This is really, really helpful.
Okay.
So, question, you mentioned several times about adding beneficiaries to make sure that, the assets, from what I understood, pass down. What are some ways that people can add beneficiaries? And then I had another one, so I'll let you answer this one and then hop on the other one.
Sure. And are you talking about adding beneficiaries to real estate or
Real
money?
estate? Definitely real estate. Yeah. Well, any asset really, but in particular real estate, since we're talking about that.
Perfect. So in Florida, as I know most of you know, there are a lot of different kinds of deeds. It's not just one kind of deed to own property. There's a ton of different kind of deeds. The deed that allows you to put beneficiaries on real estate is called, it's a long title, the first word, enhanced life estate deed. Not just life estate. That's a totally different kind of deed. So this is called an enhanced life estate deed. People tend to refer to those kind of deeds with a nickname, and which is called a ladybird deed. Long story about how that came to be. You can Google it. So ladybird deed or an enhanced life estate deed. And I will tell you, surprisingly, it is not a well-known kind of deed at all. The best thing to do is go to an estate planning attorney that's familiar with those kind of deeds, and I draft those kind of deeds not quite daily, but almost daily. But amazingly, title companies aren't 100% familiar with them. Mortgage companies are not familiar with them. Banks are not that familiar with them. So but it's the best kind of deed, and really the only kind of deed as far as having beneficiaries listed on your real estate. And it can be any kind of real estate. It doesn't have to just be homestead. It can be non-homestead. It can be commercial. That would be a little weird because usually commercial property is held in companies, in LLCs or corporations. And then, Annie, to get to your second part of the question, as far as beneficiaries on money assets, you can, if you have a checking account, you can go into the bank and let them know that you want to have a beneficiary on your checking account or savings account. Those banks of the world, the Bank of America, Wells Fargo, that kind of thing, they tend to call it a transfer on death account or payable on death account.
Tracking those, definitely tracking those.
Yeah.
So I've done estate planning and got the whole thing. One of the things that I was advised was to put investment properties in the estate plan. Can you talk a little bit about if somebody slips and falls in one of those investment properties, what happens?
Yeah. When I have clients come and talk to me and they tell me they own investment properties, I don't let them leave my office until we speak about the importance of holding investment properties separate from them personally. So usually an LLC, very popular way to hold investment properties in Florida. There's no reason to not hold it in an LLC. Some people like to put it in a trust. I think that's a horrible idea. All of my clients that come in to talk about investment properties, I put them in LLCs. And I had, for instance, a client that had 14 investment properties. We did not put all of those investment properties in one LLC. Here's why. First and foremost, when you have an LLC, the purpose of that LLC is to shield you personally from liability. And so the owner of that investment property is the LLC, not you. And so the LLC, if someone trips and falls and they want to sue the owner of that investment property, because that happens every day, they will be limited to suing the LLC. So that client that has 14 pieces of investment properties, if I put all 14 pieces of those properties into one LLC, that one person who's suing every single one of those properties now is subject to that lawsuit. That's a horrible idea. I didn't do 14 LLCs, but I think we did something like, this was a while ago, maybe 10 LLCs. And I simply paired up the properties. If there was a vacant piece of land and an expensive investment property, those were good partners because there's a lot less chance of a litigation on the vacant piece of land, presuming, than the expensive property that was VRBO'd every other week. So holding investment property in an LLC, in my opinion, is just about mandatory. I hope that answers the question.
Yeah, it did. Just to wrap it up here, you said it was a horrible idea to keep it under a trust. That is because?
Usually people have trusts that hold other assets.
Mm-hmm.
They hold their money assets. They hold investments, not real estate investments. And then people say, oh, I have a trust. I'm going to just put the real estate in there. Just happened, actually, another client a couple of months ago. And we were talking and she said, oh yeah, that piece of property out in California, I put it in my trust. And we had just finished talking about all of her money assets that were in the trust. And I tried not to do this, but I did it. And she was not very happy with me. I said, understand that you have just totally opened yourself up to liability and she did Airbnb or whatever it was, that investment property in California. She had people coming in and out of that property every other week. And that property was held in her trust. And that trust held all of her financial personal assets. And sure enough, there was a guy renting out that Airbnb that was doing what? Of course, he was, sorry, I don't know the terminology, but whatever it is with that meth stuff, whatever it is, it was bad. And he was arrested by the cops, and the whole thing like was horrible. And the property was held in her trust. So if we're talking about having a piece of property in a trust and the trust doesn't have any other assets, okay, but why not just have an LLC? An LLC is a much better vehicle to hold commercial or investment property than a trust would be.
Awesome. Thank you so much. I
Question.
appreciate you.
I want
So we have
to ask a question. Hi, Lynn. How are you? It's
Great,
Jorge.
good to see you.
Good. Same. Thank you for doing this. This is amazing.
My pleasure.
Respectful to David. I believe David wanted to ask a question first. So I'll let David go, and then I would like to go if possible. Thank you.
So David, floor is all yours. If you want to go ahead and unmute. David Evelyn. Are you still here, David? There he is. I think he's unmuted now. Let's see if we can get you unmuted. We can see you, but we can't hear you, David.
The David driving. The David. So he knows we're talking about him. David, you have a question?
If you can unmute for us, that'd be great so we can hear your question.
All right. Well,
No,
he gets.
I did not have a question.
Okay.
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 Thank
All right,
you.
Lynn. So let me ask you a question. I own a whole bunch of properties. I don't have a whole bunch of LLCs. I don't. But what about the cost of filing for every LLC versus having more beefed up liability insurance? And I know that when we talked about LLCs, we talked about insurance. We talked about how many people are in an LLC to make it unpierceable. Those are just layers of protection. You know, you're never 100%, but as I do advise clients on, get an LLC versus not getting putting it under their personal name. But when it comes to cost, and I'm thinking let's say 30 LLCs for me, I feel like I'm almost better off with some sort of umbrella liability policy. Or what is your professional opinion on that? Thank you. Appreciate it.
Sure. My opinion about that is that owning, a lot of investment properties and having the cost of LLCs is just the cost of doing business. Here's why. The insurance typically, and every policy would have to be looked at, but insurance is going to cover you as long as you're not negligent. Now, well, that's not true, but I know you will never intentionally be negligent. And sometimes that threshold is a little tough. So for instance, you have a piece of property and there's wooden stairs that go up to the front door. And we know wooden stairs in Florida will rot pretty much every single year. And so as an owner of that property, the insurance threshold for your coverage is that you can't be a negligent owner. And so how do we know if you're negligent or not? Well, the test is, and the way we say it in the legal world, is if you knew or should have known about this peril that is causing injury, that's your liability. And the insurance company generally will not cover you if you knew or should have known. So does that mean that you need to go to every single one of your properties on a quarterly basis and make sure that someone's leg is not going to fall through those wooden stairs? Yes, it does. And so if your insurance doesn't cover that, and someone who is allowed to be on the property, they're not trespassing, they're either your renter or a guest or even the mail person, and they're walking up the steps, and not only does their foot go through the step, but their ankle breaks on the way down. Oh, and also that rusty nail pierced the bottom of their foot. And oh my gosh, now the bottom half of their leg has to be amputated. And it was the mailman who had a promising NFL career. You kind of see where we're going with this. And your LLC cost every year, it will be $138.75 to renew that LLC every year. Even if that's times 10, we're talking about under $1,500. I would rather pay that $1,500 than to have an insurance company tell me, hey, it was a rotted wood step, and you know better. You knew or should have known about that rotted wood step, and we are not going to cover that insurance claim for this, soon to be NFL quarterback who's going to make $55 million a year. You come to me, I am not letting you not form LLCs. There's no way.
Got it.
It just takes one.
That makes sense. Thank you so much. Appreciate it.
Viral had a question in the chat, Michael. That was
Yeah.
related to this. Yeah.
Viral, do you want to unmute and ask it, or I can read it right here?
Either is fine. Lynn, the question was about using land trusts. This is something that has come up a lot with investors who keep asking us this question, and sellers who continue to have land trusts for certain properties that we're looking to buy from them as investors ourselves. Can you explain if having land trusts in a case like Jorge's will help, or it doesn't make any difference at all? Or what is your general opinion about using land trusts for us as investors?
I am not 100% familiar with land trusts. I've had to work with them before. My feeling, and I don't know if this is true or not, but my feeling is that the ones at least I was working with are archaic. Where they were well in place way before even LLC statutes in Florida became, something that we started doing in Florida. I mean, I've been practicing for 30 years, and I remember the days before the LLCs. I can't remember when they became statutorily, something that we all used in Florida. And so the land trusts that I have seen were pre-LLCs. I like to use what most people use and the most current things, which I think are LLCs. And again, in my 30 years, I've dealt with maybe 4 different land trusts. So I'm not that well versed. And the ones I dealt with were all kind of wonky and old. I even tried calling 2 of the 4 lawyers that drafted them, and, they were dead. So really, no kidding. So when people come in to talk to me about investment property, I go right for the LLCs. And actually, Jorge, you mentioned about how to have an LLC that's more of a protected LLC, which was a great point. A 1-member LLC in Florida is not as protected as a multi-member LLC in Florida. I like to have multi-member LLCs. And when people are a little hesitant to have more than one person, I say to them, it's probably because you don't want to have a partner and you've had bad experiences. And the way we get around that is with a very, very good which is very possible, a partnership agreement, or we call them a membership agreement, because when you have an LLC, there are members of LLCs. Therefore, we're talking about membership agreements, just like corporations and their shareholders, and you have shareholder agreements. So a multi-member LLC, in my opinion, is the way to go. And you can't have that without a really good member agreement that spells everything out, so that someday when something goes wonky, we have an agreement. We've already predetermined, how things are going to go. And just like we were talking about estate planning, there's nothing wrong with continually modifying your membership agreement with your partners in your LLC to make it relevant every year or whatever it might be.
I think this is a
Let me
perfect
ask you a
question.
question. I'm sorry, Michael. Whether it's 1% will still work, like 99% owner, and the second person and the LLC. I've been saying this for a long time because I talked to a lot of lawyers. They're saying you have to have multiple members for the LLC really to almost be legit. But 99-1 will work, or does it have to be? Because to your point, I usually do the LLC 99 or 90-10, and then the operating agreement spells out what they can do, how much they make, or if anything at all. Can you elaborate on that? Thank you.
Certainly, yes. So the membership agreement will speak directly to that, and how assets are split up. Maybe it's based on, which assets. I like always delineating who does what, the roles of each person. We get all of those expectations on paper, and most people talk about, well, I'm a 99% member of this LLC. What we're really talking about is the assets of the LLC, because the LLC is nothing, right, without assets. And so I don't think there's anything wrong with having an LLC, having a membership agreement, and even discussing the assets maybe individually. It's however best works for the members and however you want it to work, and not just about who owns the asset in that percentage, but who's making decisions and who has that power. And quite frankly, I know that anything can go wrong, but when you do all of this up front and it's all spelled out on paper and everybody understands it, it's a good start so that there are no incorrect expectations. Sometimes getting all of these particulars on paper, number one, it's hard for people, but it's better to do it now than to, 5 years down the road, that's a disaster. So you do it first thing before anything starts happening. You do all of this preliminary work, and you're going to know right away, oh, I think I might have picked the wrong partner. and it's a perfect time to pivot at that point. But yes, and having that a very good membership agreement that speaks to everything we just talked about, along with, are you going to have life insurance for each other? What if someone dies? Is their interest, even if it's a 1 or 2%, is it going to go to their spouse? Most partners don't want that. So it's an opportunity to talk about not only how this looks today. What if you die? What if I die? What if you become disabled? What if you can't do your job anymore? What if you want out? And are we going to let you sell your percentage interest to just anybody? No. If it's me, I want to know who it's going to be sold to. Better yet, let's let the LLC or let me buy your interest. And, all of those kind of things should be talked about and should be in an agreement. And to have a multi-member LLC is very, very important. Don't do it without an agreement.
Awesome. Just awesome information, Attorney Lynn. We're almost out of time. We have one more question from Oswaldo, and he asks, can members of LLCs be heirs?
I think that's a trick question. Because
you have to give you a tricky one at the end.
Here's the tricky part. An heir, you don't know who an heir is until someone dies. So I think the question is, can members to an LLC, maybe we can unmute and hear that question. I'm wondering if you're saying, can you leave your LLC to your heirs?
Oswaldo, you want to go ahead and unmute
Here,
for us
Kim.
if you can?
Yes, sir. Yeah, pretty much. You said that a way to protect is like if the LLC is in multiple with multiple people in it's safer. So part of these people in the LLC be your kids and all that, or that
Oh,
that's
yeah, absolutely. You can have your kids as, I mean, we don't want minors. You can't have minors. And the reason you can't have minors as members is because minors don't have the legal authority to sign their name.
absolutely. Yeah. That's
No
understood.
minors.
At least one of my kids I could include them and they could leave. Yeah.
Absolutely. And they can be part of your LLC. They can be a member. They can be an officer. They can own, a percentage of the LLC. Absolutely. And a lot of LLCs are, just family. Absolutely.
No, and by the way, before I go, I'm gonna let you know you took this. The way you explain this is it's so easy, and this is such a taboo subject for realtors and all that. And I appreciate this meeting was amazing. The way you explain things, I understand everything.
Awesome. That's an awesome compliment. Thank you.
Yes. Well, we're all out of time for tonight. Maybe, just maybe, we can do a part 2, Lynn. You never know.
Yeah.
But if you look in the chat, everyone, if you want to contact Attorney Lynn Wilder, her information is right there. You can email her. You could call. Maybe you want to refer some clients to her. I'm pretty sure she's very busy, but maybe she has a little space for some more clients. Also, there's some other links like our website, GraystoneIG.com. If you're interested in becoming an agent with us, there's a link there. Or if you just want to request a call from our team here at Graystone Investment Group, we will be happy to help you with all of your investment needs. So we want to thank you, Attorney Lynn. If we can, in the chat, let's, if you want to say how this was great for you, or get an emoji there, a thumbs up. I think this was one of the best trainings we've had. Lynn, you answered all the questions, and I'm sitting here wanting to know more. So if you want a copy of this recording, guys, we'll make sure it's going to be on our YouTube channel for you to go back and take notes and share with other people. So thank you again, Lynn, for being here. You're a wealth of knowledge. We really appreciate you. And don't forget, with Graystone, you invest, we do the rest. Thank you. Have a great night, everyone. Bye-bye.
Thank you.
Thank you.
Thank you.